interactive web-based lessons that are easy to use and implement, and focus on some of the most important topics in today's society: bullying, dementia, special needs, relationship issues, and 55-plus communities. These 4 topics are the focus of the Different Like Me Culture program. For more information, call 561-270-2280 and begin your pro-action approach towards these major challenges in our community. Call 561-270-2280 today and get started. Now, here's your host, Elise November.
Hi, welcome to the show. I'm Elise November, your host of Different Like Me Culture, where we attempt or are working on creating a world where empathy rules. So the Different Like Me Culture program is still in production. We're hoping to roll it out sometime the end of December, maybe in January, and we'll keep you updated on the progress of that. We're joined today by our guest, Arlene Lakin. I'm going to just tell you a little bit about her. She is a Florida Board Certified Elder Law Attorney whose law office is located in Margate, Florida. Florida Bar Association Board Certified is the highest level of recognition given by the Florida Bar for competency and experience within an area of law. Mrs. Lakin is also AV peer review rated by Martindale Hubbell. An AV rating is a significant accomplishment, a testament to the fact that a lawyer's peers rank her at the highest level of professional excellence. A lawyer must be admitted to the bar for 10 years or more to receive an AV rating. Ms. Lakin's law practice focuses on wills, trusts, including special needs trusts, probate, guardianship, as well as public benefits such as Medicaid, Social Security, and veterans benefits. Mrs. Lakin received both her bachelor's and master's degree from Tulane University and her law degree from Nova Southeastern University. Mrs. Lakin is a member of the National Academy of Elder Law Attorneys, the Academy of Florida Elder Law Attorneys, the Elder Law Section of Florida Bar, and the Broward County Bar Association. That's a mouthful. A lot of accomplishments. She also serves on the board of numerous organizations such as the Alzheimer's Family Center, JAVCO, Nova Southeastern University College of Dental Medicine, and the Seniors Foundation of the Northwest Broward, Inc. In addition, Mrs. Lakin is the founding president of Florida's Voice on Developmental Disabilities, a statewide advocacy and networking organization for families and friends of persons with developmental disabilities. And that's actually where we met. We met at your most recent conference, and it was great. Our topic that we're going to talk about today is we're going to talk about advanced care directives. What are they, and why does everybody need them? And we're hearing more and more about it. And I think it's not just something that you plan for in your old age. It's something that you need I think as soon as you turn 18. But I'm going to let you answer those questions since you're the professional. So welcome.
Thank you. Thank you for inviting me. I'm delighted to be here. Advanced care directives are legal documents that should be done by an attorney, and they're intended to prevent guardianship, which is something that if we can avoid it, you want to save the money and not have the complexity of doing that. The documents for advanced directives basically are documents that direct your care, and you do them in advance while you're still competent and don't have any problems, you're not sick or something has happened, you can't do the documents. I wanted to share a story with you from my own personal experience, because a lot of times in my elder law practice, these middle-aged kids bring their parents in who are getting old or very old, and sometimes these parents think, well, why am I here? I must be dying. There's a reason that the kids are bringing me to a lawyer now, and they've never done any documents. They've done no advanced directives. They maybe haven't even done wills or anything like that. So they come into my office, and we sit down, and I tell them the story about my son. I have 3 kids. My oldest kid is now up there. He's in his 30s. He's a doctor. But when he was 18, he went to Duke University. Very smart kid. My husband went to Duke. My son went to Duke. I'm very proud of my guys. But he's not that smart all the time. So he goes to school his freshman year. He comes home Christmas break, and he has with him the Duke University newspaper. And he says, Mommy, I'm on the newspaper. I'm on the front cover of the Duke paper. I said, fabulous. Show me your picture. So he opens up his suitcase. He takes out the newspaper, and there's a picture of my brilliant son who's flying off the steps of the Duke Library. That's how he was photographed, with rollerblades on, no shin guards, no helmet, nothing, like he's in the Olympics or something. So I gave him the mommy lecture. Why'd you do that? You could have laid it on your head, become a Cabbage Patch Kid, something like that. I don't need the aggravation. Even though I do guardianships for a living, I could do yours for free. Why have to do that? So I realized that in the state of Florida, 18 is what we call the age of majority, which means you're an adult. You're fully emancipated, unless you're not. So overnight, I prepared for my son his first set of advanced care directives, and I'm going to go into what they are shortly. But I just want to summarize what happened with my own family, because it's kind of interesting. When I see these seniors who've never done anything, and I learned that you need to do these things at the age of 18 and up. So our daughter turned 18 a few years later, and on her birthday it was basically, "Happy birthday, Kara, sign here." And her documents were ready, and she signed the advance directives. Then about 3 years later, our youngest child, we have 3 kids, it was his 18th birthday, but he has profound intellectual disabilities, so he does not have the capacity to understand or sign these kinds of documents. So on his 18th birthday, I was in the courthouse filing for guardianship, which fortunately for me, I can do it myself, and I did it. But for those people who have capacity, you want to avoid having to have this done for you, because it's expensive, and you have to have attorneys and filing fees and complexity, and who needs it? So let's talk about what are the documents and why do you need them? Well, the main document that people think of is the healthcare surrogate. That's a medical document. Basically, somebody is a person who makes healthcare decisions for you, hence the name healthcare surrogate. And it's very important that you have this. Even for young kids, I mean, they've had these terrible incidents at universities where people have been injured, and the families and the parents are stunned. They can't call in and get any medical information from the hospitals.
I had that recently happen with one of my clients, one of my patients that I see, where they couldn't get any information about their child. So I think about it because mine's 16 now, my oldest, and he's turning 18. But I've become more aware that when he goes away to college, God forbid something happens, that I can't be the mommy who says, "But you have to tell me."
They don't have
to do anything.
Yeah, they don't have to talk to you.
Right.
Well, when your kid's under 18, you're the natural guardian, so that's why you don't need these papers. But when your kid turns 18, you've got to be good to go and ready to go. So that's what the healthcare circuit is. It's all about healthcare decisions. And then there's the living will, which everybody mixes up because all these words sound alike. There's the living trust and there's the last will and testament. Those are different documents. The living will is the pull the plug document. And in Florida, 2 physicians make the medical decision. You give them the legal authority when you sign a living will. Most people don't understand how it works. They think, especially if they're listed in the living will as the person's surrogate under a living will, they think that means that they tell the doctor it's time to pull the plug. And it's not. The person that signs the document is pre-authorized it, and the doctors tell the family it's time to pull the plug.
Right. And that's something so important, because I think a lot of people have difficulty with that is, they feel the guilt of, I'm going to be doing this. But no, it's if it was my living will, I made the decision, and my family is just delivering the documents and my messenger for what my needs are. And I think that's so important for people to know, is you're making your own decisions, and then you're just giving somebody the authority to be your messenger at that time.
Yeah, it's exactly, you're pre-authorizing what you want, which is you don't want to be kept alive if you're comatose and there's no chance that you're going to get better. You don't want to be kept on life supports for all eternity. You want to be allowed to die naturally. So Florida law allows you to sign a living will. Now, there are instances where if you don't have one and the family is all on the same page and the doctors agree that you meet the medical standard where you don't need it in writing, they'll rely on the family. They do get a little scared and a little skittish when they have family members that are fighting and one's saying yes and one's saying no, and they have nothing in writing. So the living will is really, really important. If that's what you want to get it in writing, and that's it. I don't even put surrogates in my living will because I think that people still don't understand the concept, that the surrogate really has no power. They're only in the document to make sure that the wishes of the principal are carried out.
And you know what's another major issue that I run up against with my clients is when it's a second marriage and you're dealing with the wishes of, who has the jurisdiction, the kids or the spouse. And giving the permission to one or the other or all, sometimes put an and then I'm guessing that's where a lot of the fights come in. Well, maybe that's more with estate planning. I'm probably getting a little mixed up and a little ahead of ourselves.
No, that's
but,
right.
But I know sometimes, because I know I'm doing my documents now, or at least talking about it with my husband, and I know that it's hard because when you put an or an you need two people. If you put an or, it could be one or the other. And then if it's second marriage, I know there's a ton of issues. Do I give it to my wife? Do I give it to my children? Who should be the one? That's major issues.
That's the issue of who you want as your agents, which I do want to get to. I want to save that point.
Okay.
So remind me, Elise.
Okay,
We're
I
gonna
will,
do that.
I will.
How you pick your agents. But you can have more than one agent serving at one time. You can do it either or. And so that's true. But then you're stuck with that. They both have authority. The good news is if one's on vacation, the other can do whatever needs to be done. The bad news is they both have equal authority. So if they don't agree, you're basically, well, you won't know it because you'll be real incompetent at that point. But they can lock heads, if they both have equal authority. And then the third party, the bank or the hospital, the doctor, they don't know who to go to, who to rely on, because they're both, one saying yes, one saying no, which brings us to the most important, what I call an advanced care directive, but technically it's not in the same part of the Florida statutes, but it does address what you want done in the future, and that's the durable power of attorney. And that's the document that legally makes somebody else you for everything other than medical care. So people think it's only for banks. It's broader than that. It's for anything under the sun that you can think of. You're crossing the street, you get hit by a car, and you survive, but you survive in terrible shape. So now somebody has the authority to hire an attorney to go after the person that hit you and drove you down. Or it could be for Medicare, it could be for anything that you need. If you need to contact an insurance company, the power of attorney is the document that somebody else needs to have for you. It's very important that those are done. That's more important than pretty much anything. That is really important. It avoids guardianship as well. I call it an advanced care directive. Technically, it's not defined as that in the statute, but it is very important. It's kind of the soulmate to the healthcare surrogate. And I tell people it's better to use the same agents. So we'll get on the topic of agents, who to use. You want to use the agent who, number one, you trust and think is the most capable. Doesn't matter whether they live in the neighborhood, up the street, if they're related to you or not related to you. Who do you trust the most? Because this is a very important decision that you're making, and they need to be competent and capable.
But your power of attorney has access to everything.
Right?
Oh,
yeah.
They could, wipe you out if they want to.
Well, technically, at least, the power of attorney is actually the document. People always say that. I always visualize it kind of sprouting feet and running around doing things. Sorry, I can't correct you.
I might use that, but good.
Yes, but no, the agent is called the attorney in fact, which doesn't mean you're an attorney. I don't know where the term comes from, but that's what the agent is under a durable power of attorney. And yes, they have the authority to pretty much close you out, take out all your accounts and do really bad stuff. The challenge is if you're not on top of them, and you better just trust the person you pick, because you shouldn't pick anyone that's not entirely trustworthy. You need to tell them ahead of time what you're thinking of doing. This is another important point. Be sure that individual wants to do it. I've seen it where people assume that their married daughter with 5 kids wants to have that responsibility, and it's a huge responsibility. So you need to make sure that they agree. Maybe they'll say, no, Ma, pick my brother. I'm really busy, and I wouldn't want to have to make those decisions and come to Florida to check on things, and pick my brother because he's more available. He has no kids or whatever. So sometimes you may be in for a surprise that the person you're thinking of picking doesn't want the job. Mm-hmm. Or that's when you want to put them to serve together with maybe the daughter and the son.
Do you ever feel I feel like sometimes people feel pressure to put one over another?
Yeah, all the time.
And then sometimes they don't make the right decision as a result, and you feel like you ever get that gut reaction, like something's not right when you're doing somebody's documents and the family's sitting around? And how can we help people, I guess, that have those really difficult decisions to make, and help them to kind of give them back the control that they sometimes feel when they're sitting with family members, that they feel that they have to appoint them, but they're not really comfortable appointing them?
Well, that's the challenge for the attorney. it's sort of a gut instinct. If you sense while you're in consultation with this family that maybe the mother or the father are feeling a little uncomfortable or they're feeling pressured and this one kid brought them in, or a bunch of people have brought this person in, then sometimes what I'll say is I'll ask them nicely to step out so I can talk to mom alone or
Love
dad
that.
alone.
Okay.
And then I have the opportunity to see if this is really what they want. It's kind of, my call, depending on what you pick up. But what I do with new clients the first time I meet them, which I learned the hard way, is first of all, they have an intake sheet, like a doctor's office, name, rank, and serial number. Where do you live? What's your phone number, your email, etc. And then on page 2 would list your kids, if they have kids. Not everybody has children, but most do. So when I get to the kid part, and since I see so many seniors, when I get to page 2, I flip it up, and there it is. Like they have, say, 3 kids. So I'll say to the lady, Mrs. Smith, you have 3 children, I see. How do they get along with one another? And this is literally after she's sat down for maybe a minute, maybe 2 minutes, and I've offered her cold drink or something to get comfortable. So it's very interested because they don't know where I'm going with this or why I'm asking. They're kind of caught unprepared. And so I usually get what I believe to be the truth out of them then. So that's when they'll tell me, well, I haven't talked to my son Jimmy in 20 years, so I'll make a note of that. And I know ahead of time what kind of family I'm dealing with, so I know pretty much where I'm going to be going in terms of whatever I'm going to be doing. So when it comes to agents under these documents, I tell them, number one, again, be sure whoever you pick you think is the most capable. It doesn't matter if they live next door to you. If the more capable kid is the one in Oregon, then that's the kid you pick. And if they don't get along with one another, you don't want co-agents. If they don't get along now, they're not going to get along when things are difficult.
Right. So you advise them on what to do, or at least you say these are the potential problems that you could run into down the road.
Yeah, I'm very proactive. I just don't give them a form to complete, and then I just do a document.
Right.
They need to pick agents, and there's something very interesting that I learned. Because if you listen and you pay attention in life, you might learn something. So I get this form in the mail from Smith Barney, Morgan Stanley Smith Barney. We have an account with them. And the form was regarding my durable power of attorney. I have my 2 adult children on there to take care of me if there's a problem. And now they have a form when there's co-agents. They want the individual, the principal it's called, to select which of those co-agents the companies, or could be a hospital, or the physician, turns to when there's conflict. And I thought that was really brilliant because I didn't really know how to address that. So I sorry, Smith Barney, but I kind of stole the verbiage. And it's in my documents. So now, and that's for my healthcare surrogates when there's more than one. That's in my durable power of attorney. And that's even in my trust for the trustees. They may be serving either or, but occasionally people don't agree. And they're not necessarily a tiebreaker if you do 3 people, because sometimes there's slightly different slants to the position, so it's not one's yes and one's no. There may be a third position.
Right.
So you still want to have your first choice. And for some people, you're right about that. Some people, they don't know who to pick, and so they think, well, I'll pick my oldest kid, or they'll pick this person or that person. But it's really important that they pick the person that, A, has agreed to serve and do the job, so you got to call them ahead of time. B, is the most capable person.
And the one who's not going to potentially say, mom's not really great anymore. Let's just throw her in the nursing home, and we're just going to live off of her money and whatever.
Well, that's
right?
where the trustworthy thing comes into play. They got to be pretty bright and pretty competent, and you trust them because you're going to give them the document. I've had people say, well, maybe we'll just can you hold them in your file and not turn them over? And some attorneys have worked out, like they call it an escrow agreement, where they actually hold the documents, and the family is advised that the lawyer X, is holding mom's power of attorney and so forth and so on. And I've never done it. I just don't believe in doing that, or I just don't. It's not something I would want to do as an attorney.
But the person themselves, you could give the person themselves the document,
Oh,
and
sure.
you can say, should you need to, you can contact my attorney, or when the time is right, I will give you an envelope with all the information.
Oh, I give my clients copies of these documents to give to their kids or to whoever they are. Not everybody has children. So usually if they're married, it's their spouse. And then if they don't have kids, that's very interesting because the Florida statute for durable powers of attorney was rewritten entirely. It went into effect October 1st, 2011. So those of you who are listening who have older durable powers of attorney, if it was properly done, you don't have to change it. But the new statute, if you're going to do something new, hopefully your attorney knows what this is all about. But they have a section that we've nicknamed superpowers or special powers. And there are 10 or 11 powers where you have to individually sign for them. And the reason that law was passed is because there were too many people taking advantage of the document and going behind this person and doing all kinds of bad stuff. So now you have to sign individually for 10 or 11 of these superpowers. And the best one I love is the last one of the superpowers, where they basically tell you if your agent, whoever you're putting in your document to take care of you, your attorney, in fact, under a power of attorney, if that person is not an ancestor, a descendant, or your spouse, they have to meet that definition, which is very narrow. Then, in that case, then, I have to have that opportunity to explain, are you sure you want to name them? Essentially, I'm turning legalese into plain English, but that's the last of the superpowers. And it's true because people are sometimes dragged into a lawyer's office, particularly when they're recently widowed and they're getting a little frail and somebody befriends them at their church or their synagogue. And maybe their motives aren't so kosher, as they say. And so now they drag them in. I had a case once where a gentleman was brought to me, driven over by a woman he met a week before. They lived at Century Village, and his wife had died a few months previously. And I didn't know any of this till we sat down and I took his history. And when I realized that the lady next to him, he'd only known her for a short time, I asked her nicely to step out and sit in the waiting room. He was doing his will and documents like that. I said to him, how long have you known this lady? He says, well, I met her on the trolley at Century Village last week. And I said, last week, are you kidding? Because he wanted to leave her everything he had. And I said to him, well, why don't you leave the money to charity or something like that? Oh, no, this lady's very nice to me. 1 week. So I decided at that time that we need to let him think about it.
He needs a cooling off period, I think.
He needs a cooling off
period. Because who knows what she did to him to get him.
Exactly.
Oh, my God. But would you ever... I mean, I'm guessing he seemed competent to you, but I'm guessing at certain times, to have such a major decision all of a sudden to you question somebody's competency.
Yeah, but then I'm not a neurologist. I'm not a psychiatrist.
Well, would you call in a neurologist?
Well,
would you ask? Could you ask for that type of thing if you're not comfortable?
Yeah, I could say to this person, they may not come back because they're not competent and they don't remember to come back. Some people present better than they are.
Better.
Well, I did not help that man that came in with that situation. It was interesting. Not only was this woman with him, but her daughter had driven them to my office.
That's a little scary.
Yeah, and she was sitting in the waiting room. So when I walked him out, I said to them, they stood right up. They really were anxious to know whether he had signed any documents or when he was coming back to sign these documents. And I just said, well, Mr. So-and-so, he's going to be thinking about it, and he'll get back in touch with me in another week or two. And they were very disappointed, and then they took him away, and I never saw him again.
And they probably walked into another attorney's office the next day, and hopefully somebody else was just as ethical as you are. But sometimes they're not. So also, you know what? I think you're bringing up an important topic here is people who prey on the elderly and the lonely and the people who have memory disorder or things like that, where it might not be visible, so to speak. It's kind of more underlying, and until you talk to somebody for a while, you could really tell what's going on. Or somebody might be just very needy, or we're not sure why. But I guess for all the kids of who have parents who are aging, beware. My grandfather, actually, he was married for quite some time, but she took him to the cleaners. She did. She took him to the attorney and changed his documents. And it was very, very, very challenging for the family. I was young at the time, but younger, so I wasn't really involved. But I know my dad and finding out afterwards, after he passed, and finding all of these documents, it was disturbing. It was disturbing.
Do you know, Elise, do you know what a person is who's a grifter? Have you heard the term somebody's a grifter?
What's a grifter?
It's like a gypsy. I don't know the real distinction, but to me they're like one and the same. I had a situation where I had a client and his son was called by the neighbors of his elderly father because they noticed that people were like removing furniture, literally, and appliances from his home, and they were very concerned that he was being robbed, but it was very slow. It was over time. And the man had a girlfriend. It turned out she was a grifter, a gypsy, and her kids, adult kids, they were all part of this group. I don't know if it's called a clan or what you call them.
A thief?
Well,
Group of thieves?
it's just a different
But it's-
culture.
yeah, but-
and then they cleaned him out over a period of
Oh,
weeks.
my goodness.
So the son and his sister flew down here, and they immediately moved for guardianship because obviously something was going on. Daddy was unaware of it. He came to see me, and he said, "I'm just a fool for love." That's what he called himself. But sometimes they're not overtly incompetent, so you can't always tell as an attorney. And I don't like to play this, where I do like a game, like who's the president kind of a thing. That's not my role, and I'm not competent to do that. So if somebody wants to do a will or a trust and it's a little suspicious, the circumstances, I may suggest to them that they see a psychiatrist or neurologist for an evaluation so nobody challenges it later. They may or may not want to do that. And there's a flip the coin. There's people that say that if you do that, then it looks like you were yourself concerned about the person's capacity. It can be used against you, too, and which is kind of an interesting angle. Some people videotape the signings of a will or a trust to be sure that
Right.
anybody wants to challenge it, they can see that the person was competent.
Exactly. Well, Steve, my husband, is a neuropsychologist, so he will do the competency right then and there, and then they sign the papers. So this way, you have the competency, determination right then and there, and then you say, okay, they're okay, sign the papers. So this way, if it ever comes back, he could go into court and testify at that time that they signed the papers. They were fully competent and fully aware of what they were doing, who they were giving to, who they were changing to, and it was all on the up
So
and up.
it's done contemporaneously with the signing of the documents in front of an attorney?
At that moment, yes. Well, the testing is done, and then the attorney comes back in, and it's either competent or not, and then you either go ahead or you don't go
that's
ahead,
very
and the family
interesting.
typically will pay for it.
Yeah,
so
very
that's
interesting.
something. I know we have just a couple of minutes left, but I want to let people know how to get in touch with you should they want to. So we had your information. There we go. Phone number's up on the screen, but it's 954-975-5159. But I think probably the easiest way to learn about you is to go on your website.
Yes.
Yes?
I hope they'll go there.
ArleneLakin.com. And I want to thank you so much for
You're
joining
welcome.
us
It's
today.
a lot of fun. I've enjoyed it.
Yeah, it was great. And if you have any questions, you could also email Elise November at differentlikeme.com. Thank you.
You're welcome.
Thank you for tuning into Different Like Me Culture with Elise November. Join us every Monday at 6 p.m. Call 561-270-2280 for more information. And tune in again next week for more Different Like Me Culture. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors.